This opening fight is not really about a move-out date. It is about leverage. Both sides understand that whoever controls the living situation gains an advantage heading into the larger custody dispute. The father's attorney frames the issue around stability and access to children, while the mother's attorney quietly ties housing plans to future financial rulings.
Three of those kids in the residence half the time and contends that more than half of the responsibility for those three children was on her. She took the kids to daycare more than half the time. She was responsible for putting the kids to bed more than half the time, responsible for those things. Ashley Davis contends that he would sometimes come home late as an idea to give her space, Your Honor. If you would look at my petitioner's exhibit, it's my exhibit 14, Your Honor. There's a couple of text messages from dad to mom at, my first page of exhibit 14, Your Honor, is 3:14 in the morning on a Thursday evening. It's Friday morning, Thursday evening, that he's out late, hanging out with friends, doing whatever, not coming home. Sorry, Your Honor, the next page, again, is 3 o'clock in the morning, woke up. I doesn't know what's going on with the child. Page 15, Your Honor, it's another couple examples that he goes out on Wednesday evenings over to friend's house and will stay out all night on Wednesdays. We'll drink alcohol, we'll hang out over there, and won't come home. We'll stay the night at the friend's house in the middle of the day, and we'll text my client at 1 o'clock in the morning that he's not going to be able to take the party's child to daycare, or that at 6 o'clock in the morning that he's not feeling well because he's hungover and was up until 3 o'clock in the morning drinking alcohol, Your Honor. Couple examples of that where he's coming home and asking her to take the child to daycare because he's not home, or is asking her to take the child to daycare and she's already done it. He texts at 7 o'clock in the morning and says, "Can you take our youngest child, who's 2.5 years old, to daycare for me because I'm not home on time to do that?" And she's already got the kid all ready to go and dropped off at daycare and on her way to work before he's even home from whatever he is doing. My client contends that she's nervous that type of behavior would continue if she's not around. Again, Your Honor, weekend parenting time, extended periods of time from Friday to Sunday evening, my client is nervous that dad will drink alcohol and hang out in bars and things like that with the children. He's been doing that with the 10 and the 12-year-old on multiple instances, has no reason to think that he won't be doing that with the 2 or 3-year-old. Your Honor, the weekend in question, when my client gave dad some extra parenting time, she had an event to do on Friday, had the kid with her. The kid did not spend the night over there on Friday, as Ms. Davis's Ms. Davis's motion contends. Didn't spend the night on Friday. She did let him spend the night, or did let him have overnight parenting time on Saturday. When she went to pick the kid up on Sunday, dad was cagey with her, didn't want to agree on a time to do an exchange, even though it was an extra weekend that she granted, was cagey about those things, was cagey about communication. And when my client went to pick her up, again, the daughter, she's 2.5 years old, was wearing a diaper for 5 or 6-year-olds. It was way too big for her. And my client has concerns about his ability to co-parent or to parent 3 children all at the same time without her help, based on her experience when she was there to help. It's twice as much responsibility with 3 kids and half as much help. My client contends that parenting time should stay the same until parties kind of have some opportunity to attend a domestic conciliation or some other kind of alternative dispute resolution, Your Honor, so that she can try to work on a step-up plan. She wants, her daughter to have time with her half-siblings. That's why she gave parenting time on Mondays, on Tuesdays, on those weekends, specifically to line up with her siblings' parenting time. Just can't trust dad to have extended parenting time at this time with a daughter that young, with 3 kids, and half as much help as he's traditionally had.
All right, Mr. McGumball, and at least for the next 5 or 6 weeks, Adam would be living with his mother, would he not?
I believe so, Your Honor.
Isn't there a greater comfort level with a grandma in the house than there would be if he were on his own?
I believe so, but again, they're asking until a couple minutes ago to take full possession of that house. If we'd be okay with supervised visits, I believe Again, that's kind of why I think your visit supervised by his parents while he's over there, while she's there. Make sure that grandma and grandpa are there during parenting time. Again, Your Honor, that's kind of why I thought that alternative dispute resolution or some kind of domestic conciliation where the parties could work on maybe a step up plan, some kind of written plan that's good for the parties and good for their minor child so that parties can kind of work together to work on something that works for everybody.
Did your client
You're
have to go through a step-up plan before she took primary custody of this child?
No, Your Honor, my client
The
had
other
been,
parent does, but you're saying the other parent does.
based on concerns from my client, I believe that's reasonable, Your Honor.
Hmm. Ms. Davis, do you agree that that's reasonable?
No, Your Honor, and I will tell you, I tried to again. I thought it was weird that my client didn't have overnights initially for an almost 3-year-old. And when I talked to Mr. McMullen, he was like, well, maybe this is, in my opinion, about mother's control. Again, my client, when I talked to Mr. McMullen, he was like, well, he's not even sure, she's not even sure if the other two kids are there. My client's mother is here again because I was like, had I known this was an issue, I would have had her sign an affidavit that yes, he still has the other two kids on Monday and Tuesday. This is about control for mom. And again, even though they had been sharing, I'm not going to go into, but when they talk about Wednesday nights, my client doesn't have the kids on Wednesday nights, and they were kind of doing an every other day thing with Brecken and kind of alternating. And again, I think it is ridiculous. They have this 3-year-old child. They have been parenting this child for 3 years together, but because mom is now, hey, we're filing for divorce, you only get 5 to 7 on these 2 days, and you can't even have overnights on the weekend. I think the court should do shared. Again, recommending domestic conciliation is a way to delay and delay. We need to get this kid on a schedule. I will tell you, Mr. McMullen was like, well, when she asked the 2.5-year-old if she saw her brother or sister, she'd be like, no, this is a 2.5-year-old. When you talk to a 2.5-year-old and you ask them what they did, nothing. I don't know. You can't believe what a 2.5-year-old says. Again, not that they just don't have that concept. So I'm asking for shared residency. I agree. It shouldn't have to be supervised. I'm very offended that, oh, well, it can be supervised by his mom and dad. Again, he is living with his mom. I don't think it needs to be supervised.
The mother's
They
case
have given
depends almost entirely on risk assessment. Instead of arguing that the father does not love the child, her attorney argues that he cannot reliably manage responsibility when nobody is watching. That distinction matters.
They have given no reason except again she doesn't like and he was doing this, but again I've got tons of text messages where she was doing this. I will tell you again, my client would say she would go pick up the child, then take her back to work and work till 7 or 8, which again, her time, she can do what she wants. But I'm asking the court adopt a shared 2-2-5 schedule so that Brecken can continue to be on the same schedule as her brother and sister Harper and Emmett.
All right, Mr. McMullen?
Your Honor, again, I think these concerns about dad's behavior are legitimate. He has several parenting concerns that my client witnessed for long periods of time. My client has lived experience of not being able to share equally in responsibility for the party's child, especially one who's 2.5 years old, on with dad. The one overnight that she decided to let him have during the pendency of this divorce did not go well. She returned with a diaper that didn't fit her, was cagey with exchanges and all of those types of things, Your Honor. He had one opportunity to have that go well, and it didn't. Your Honor asked me if she'd be more comfortable if parents were there. I said yes, they would, and then Ashley, it presents that that's absurd that I would say she'd be more comfortable with grandparents present. That's a perfectly reasonable thing for her to be more comfortable with. And again, Your Honor, this is a temporary parenting plan that doesn't only apply to when he's living at mom and dad's. He's going to move in to the temporary or back into the marital residence in 4 or 5 weeks from now. We're not, Ashley Davis isn't proposing that parenting plan only apply until then. I think that, Your Honor, these concerns are pretty legitimate about his behavior, his drinking, his staying out, his ability to care for 3 children as opposed to just 2. You know, a 2.5-year-old takes a lot more work than a 12 and a 10-year-old, especially when you're on your own. My client, again, contends that she was responsible for more than half of the parenting responsibilities for all 3 of those children, let alone the youngest.
Your Honor, my client had shared residency of his other children before he was involved with Mrs. Bezdek. Regarding the weekend, which I didn't specifically address, she had left the child Friday night, didn't come back until wee hours in the morning. And then again, yes, did leave Saturday morning, and he had him all Saturday night. My client disputes that the child wasn't taken care of. Again, this is about control for mom. And I believe, again, I'm not saying it was absurd that mom be around. I'm saying it's absurd that they want supervised parenting time. Hey, they have concerns. Again, my client has been taking care of Brecken during his parenting time. Again, she said, well, I don't even know if the other two kids are there. They are there. This is all about control for mom. I think that they shared residency. Again, if it will ease, he's living with his mom for the next till June 24th. So that will, again, if they need eased into it, my client disputes he needs eased into taking care of their almost 3-year-old child, Brecken. And again, yes, he can take care of a 3, a 10, and a 12-year-old at the same time on Mondays and Tuesdays and every other weekend. There's no proof that he can't, but because she doesn't feel comfortable, she doesn't want to do it. And again, it's about control for her, and that's been the problem.
Thank you, counsel, for your respective arguments in this case. The court needs to make a decision today regarding a temporary parenting plan. The court will first note that the first parenting plan that was entered in this case was basically just based on one side suggestion as to what the proper parenting plan must be. The issue before the court today is Adam's recent behavior or his current status in a situation where he cannot adequately parent this child. This court will conclude at this point, no, he is quite capable in the view of this court of being able to care for a 2-year-old, a 12-year-old, and a 10-year-old all at the same time. After all, this court shared in raising 5 all at once. So I know it can be done. With that said, the court will adopt what has been referred to as a 225 shared custody plan as a temporary order in this case. However, the other suggestions regarding a holiday plan, this court specifically rejects that we're too soon to be talking about holidays with the possible exception of Father's Day. And it would be the intention of the court that father, of course, gets to see his child on Father's Day. I am presupposing that this case will be totally concluded one way or the other prior to any other meaningful late year holiday that might arise. So as far as the 225 plan, the court will adopt it. Supervision will not be required. Adam, would you unmute yourself, please?
He can talk on my computer. I mean, it's covers. Do you want to talk to him?
Yes. Yes, sir.
Can you hear him?
Yes, I can. You've made certain requests to the court today, and your attorney has argued your position well. I don't need you to rehash that. But essentially, you need to step up to the plate. You're asking to take on a lot more responsibility, a lot more. You're going to become responsible for a small child, as you know, gets into everything. Actually, I see the 12-year-old and the 10-year-old as assets in that situation rather than detriments. Anybody who can keep a watchful eye on a quickly moving 2.5-year-old, I think is an asset to you. I'm also a little more comfortable with implementing this plan because you're staying with your mother. Grandmas usually are great caregivers and great substitute caregivers. So under her watchful eyes, I'm even more comfortable with the current parenting plan, which the court has ordered. But I think you've heard the concerns that the mother of this child has.
Yes, sir.
I will expect you to be that child's primary caregiver, not anybody else in the house. You need to work your schedule so that during your parenting times, that child is the priority.
A collision between two completely different interpretations of the same facts. The mother's side sees caution. The father's side sees control. Once the word control enters a custody dispute, the battlefield changes. Now the court is no longer evaluating only parenting ability.
And not just leave the child there with someone else who can watch the little one, You need to take that primary responsibility, which I presuppose mother is already doing on her side.
Yes,
So
sir.
when it comes to going out or extended work or any other social activity that you may be inclined to be involved in, if you can't take your 2.5-year-old with you safely, then you need to change your behaviors and just do that kind of thing during her parenting time rather than yours.
Yes,
This
sir.
all seems like common sense, and it seems like it's really easy for the court to talk about, but in practice, it can be very, very difficult. But you've asked for this responsibility. The court would expect that you're going to step up to the plate and perform the duties that you're wanting the opportunity to perform.
Yes, sir.
So this is a temporary plan. If this doesn't work for whatever reason on your end that makes it unworkable, the court can always do something different. But we're going to give you an opportunity to prove that you are a shared residential custodian in reality.
Thank you, sir.
Your
Okay, it's
Honor,
up to you. Yes.
sorry, and then I didn't know if we were ready to move to my other two issues.
Well, I'm going to address another issue.
Sorry.
Obviously, this is going to result in modification of any temporary child support order. I don't know if there's any real dispute over the numbers to go into the worksheet. I think both parties have a reasonable handle on the other's income. And the court's going to order any modification of child support based on a shared residential custody schedule to be in effect as of May 15th. Ms. Davis, I'm sure you're quite capable of doing that shared residential custody worksheet, or perhaps you already have.
Your Honor, I had prepared a shared residency worksheet, which was my Exhibit C with mom paying the direct expenses. But in addition to that, my client had requested $500 in temporary spousal maintenance,
Okay.
and that worksheet was on that.
All right. So, have you done a worksheet without spousal maintenance? What would the base child support obligation be, and who's paying it?
Your Honor, if I may, for just a second, I believe there's a little bit of a dispute. It's not much, but I believe that parties' income on Miss Davis's child support worksheet is slightly inaccurate. I have argument to make about that later if you'd like to, but I think we're not far off, Your Honor, but it is a little bit different.
All right. Were the numbers pulled off the W-2 forms from 2025?
Your Honor, I used their year-to-date income, and on my domestic relations affidavit, I actually, on page 38 of my exhibit, I tell you how I do the math for each of them, based on their pay stubs, which were actually attached to the domestic relations affidavit. And so that's,
Okay. Mr. McMullen, how did you compute it?
Your Honor, one of the things that I believe is incorrect about Miss Davis's calculation, both parties are awarded a one-time HSA distribution from their employment. It's about $900. They get it at the beginning of the year. Ashley Davis has calculated that as if it's because she's divided the party's income through March. So she's divided that $300 or that $900 divided through March instead of through 12 months. So it's overcalculated both parties' income by a few $100s a month, as well as my client received a one-time $200 employee appreciation bonus at the beginning of the month. So her income is actually, $1,100 divided by 3 months as opposed to $1,100 divided by 12 months. So there's a couple disputes there as to the amount of the total amount of monthly income. I believe Miss Davis has dad at about $5,300. I have him at $5,085, so about $200 difference. I believe with my client, she has them at around $9,700, Your Honor, and I believe my client income is around $9,400, $9,300 and some change. So it's about $400 a month difference for her as well.
Well, the court has always had a problem with using just a portion of a year and extrapolating income for an entire 12-month period just based on a few months. Quite frankly, I think for a temporary orders purposes, this court would be comfortable if the parties had the same job for the entirety of last year, simply using 2025 year-end
Your Honor,
incomes for the parties, unless there's some reason not to.
Your Honor, I can do that. My exhibit I and J are, has Mrs. Bezdek's last pay stub for 12/31/25 and my client's W-2. So we can definitely use that income. The only other thing, which I think, again, both parties used to put their money in the joint account, and then that was being used to pay the daycare. And so again, I think because they have shared residency and it creates a disparity if they're not equally sharing in the daycare costs. And I would propose the parties simply alternate paying every other week for the daycare and they share that. And I can prepare a child support worksheet based on shared residency. I still believe my client is still requesting $500 in, again, temporary spousal maintenance. Mrs. Bezdek makes either 9,300 per month or 9,700 per month, depending on how you look at it. And my client makes 5,300 or 5,085 based on his domestic relations affidavit. And that is Exhibit E. And if you go to page 4 of the DRA or page 40, that is where I did the math that shows if he's given the $500 in temporary spousal maintenance, I will need to revise the child support worksheet, but it was based on shared.
Once custody is resolved, the conflict shifts from parenting to economics. This section exposes how financial disputes often hide beneath family court arguments. Every income calculation suddenly matters because small numerical differences create larger legal consequences.
And them sharing the daycare, I think it'll be a little bit different, but the child support that my client would owe mother based on mother paying the direct expenses would be $287. And so the $500 helps offset that cost, Your Honor.
And your client is living with his mother right now.
My client is living with his mother right now, but
That needs a spousal support subsidy from his wife.
Well, the reason the spousal support was when he gets back into the marital residence, that I have his expenses based on that. So I agree he doesn't have that right now for until June 23rd, June 24th, when he gets back in the marital residence.
All right. With what appears to be an offer to defer the start of spousal maintenance, Mr. McMullen, what is your position on this?
Your Honor, my position is similar. If she's basing it based off of, my client's been the client or been the party who's been paying the child support services. So if she's proposing going forward, the party split that 50-50, that's great. That's not been what the parties have been doing. And so, her domestic relations affidavit indicates that her client pays $531 per month in spousal maintenance, in child support, to pay daycare. Sorry, Your Honor. And that's not the case right now. Also indicates that he pays $775 in rent. That's not the case right now. Again, he's never been the party who paid rent. So that's, $1,300 as an expense on his domestic relations affidavit that shows that he's got a monthly shortfall and doesn't take into account the additional $531 my client does pay that she didn't get credit for daycare. That $1,300 alone says that, he says he's $700 in the hole. You add $1,300 to that, he's up hundreds of dollars. He's got, he's got a positive net balance at the end of the month, and my client's proposed net balance is much lower. Additionally, Your Honor, if he comes in and is paying that $775 per month as rent, my client would be in a new residence as well. She believes her mortgage is going to be around $2,500 per month. So, Your Honor, I believe this request for spousal maintenance is simply a bad faith request to get around child support. In their motion, they say that child support or the spousal maintenance amount should go up if my client remains primary. It goes lower if they are shared. I believe this is strictly an attempt to circumvent any child support payments that would have been made payable by dad by indication that they've asked for a lower amount. Why would he need more support to spend less time with his child? I believe if parties are going to be shared, my client's going to have increased expenses, and he's got, his domestic relations affidavit is not indicative of what his current circumstances are, Your Honor. Additionally, on that same page, page 40 of Respondent's exhibits, Respondent lists several nominal monthly debt payments, $50, $25, $25, $75, Your Honor. Balances are low, typically below $5,000 on each of those, except for the student loan payment, which is $39,000. Your Honor, that student loan payment is in deferment, so he's not making payments on that. My client contends that the Intrust Bank 401k loan on the bottom page of that says it's a $24,000 loan that he's paying about $1,300 per month, said that the purpose of that 401k loan was to pay off each of those debts with those small balances, and that was the purpose of that loan. And by listing both those nominal debts and the 401k loan, he's essentially double dipping those debts. He borrowed money against his 401k to pay off those debts. He's included both on here. Believe that respondent's indication that he's in the hole hundreds of dollars per month is extremely inaccurate based on the current circumstances of the parties, Your Honor, and that there's no need for spousal maintenance, especially considering he's full-time employed, got a good job, and has not been paying rent. My party's been paying rent historically, Your Honor. It is my exhibit, exhibit 12, Your Honor, that shows that, or sorry, Your Honor, not exhibit 12. Where is it, exhibit 12? On the two pages. Sorry, Your Honor, it's my exhibit 11. Page 076 is an example of my client, Courtney, paying the $775 per month from her Venmo account. My client's the one who's consistently made that payment during the time where the parties were married and splitting expenses. My client paid a bigger percentage of the client's monthly expenses because her income was higher. Respondents had plenty of opportunity to save money, is living cheaply right now, will continue to live cheaply if he moves back into the rental from his parents. So my indication, Your Honor, is that there's no need for spousal maintenance. It's simply a request to offset any child care costs or child support.
Your Honor, I completely disagree with that. If you look at their exhibit 76, 77, that is a joint account that had both parties' money and from their job going into it. So again, she may have physically been paying the Venmo payment for daycare, but again, it was using it with parties' joint funds from their joint account along with the rent. And I will tell you that the 401k, first of all, the student loan, I didn't put an amount. It's got an X. He's not paying on his student loan. That's not included in it. He did have to take out a 401 loan. If you look, even though, again,
the spousal maintenance argument reveals the sharpest credibility battle of the hearing. The father's attorney focuses on income imbalance and future housing costs. The mother's attorney attacks the foundation of the request itself.
It's marital debt. It doesn't matter whether it's in his name or her name. He's taking the lion's share of the debt, again, because it is in his name. And so he did use that loan to pay off debts that are not on there. But these are still debts that, yes, he has. And so she makes over $9,000 a month. My client is asking for $500 a month in temporary spousal maintenance. Again, this is temporary. This is not forever. This is not final. And yes, the reason, because again, my client, regarding the income, again, he doesn't have the funds to be doing this, and he's in the hole. So yes, he can save money, but he's not going to always live with his mother, and again, need to be back in the marital residence so his other child can continue to go to Andover Sunflower Elementary. That's the address that they use. I think, again, Mrs. Bezdek can afford $500 in spousal maintenance, and she's buying a house with a $2,500 mortgage payment. That seems very high for a mortgage payment or for rent. I mean, again, maybe she needs to be renting and not buying a house. I don't know anything about that, but I believe $500 again, effective June 24th, I think is not unreasonable. Again, this is a temporary order and temporary spousal maintenance, Your Honor.
Very well. Having heard arguments of both parties regarding the issue of temporary spousal maintenance, the court will enter an order at this time denying the request for temporary spousal maintenance to be paid from the wife to the husband. This court believes that proper analysis of need and ability to pay needs to take place based on a post-June 24 analysis rather than today. This is a family clearly in transition. Their financial circumstances on each side are in transition. Until the parties get settled into what are going to be new residences for both parties, it does not seem prudent for this court to require one party to pay a spousal maintenance subsidy to the other. With that said, there could be, perhaps in the finalization of this case, as far as a final order in this case, a need to revisit the issue of spousal maintenance. The court makes no order in that regard. However, at this time, the court denies the request for a temporary spousal maintenance order. All right. Were there any other issues
I think
raised by your motion?
I think the only other issue is whether or not the parties equally share in the daycare costs and alternate paying that weekly.
All right. Mr. McMullen, do you take a position on this?
Your Honor, that's okay with us. Just my client's been handling that expense on her own for the last several weeks and would ask that if that's how the parties are going to go forward, that she be reimbursed for the payments that she's made over the last several weeks.
They didn't have shared residency then.
Right, Your Honor, but it's daycare that my client's been sharing or paying the line share, just requesting reimbursement for his portion of the daycare for the party's shared child.
Wasn't that contemplated by the original child support order in the case?
Oh, I haven't received child.
We have not received one payment of child support, Your Honor.
Okay, when was child support ordered to be effective?
May 1st, Your Honor.
Okay, well, he'll owe child support for the first half of May. The shared custody schedule will take over as of the second half of May. So he'll owe one half of the original child support order issued in the case. For the record, announce that figure, Mr. McMullen. At least the monthly figure. Math would be pretty simple from there.
Give me just a second to find that number, Your Honor. I apologize.
Ms. Davis, I'm going to want that included in the order which stems from today's proceedings that you will draft. So,
Yes, Your Honor. I understand the ruling. He will pay one half of the original amount of child support, and then effective May 15th, the shared residency goes into effect.
and the court will deny any reimbursement request made by the mother in this case.
Your Honor, the monthly child support in full payable by dad was $512 per month. I believe one half of that is $256.
Okay, that reconciles with the court's math. So if you'll include that in the order, Ms. Davis.
I will, Your Honor.
I hope after today, a new period of parental cooperation can take place. You're going to be co-parenting for a long time. So the sooner that there's a mutually cooperative relationship established, the better for this little one. Because what we really want to make sure we don't do is mess up this child in some way. So I think we probably got two good parents who want to be parents, and I have no reason to believe you're not going to be good parents. So good luck in that regard. Ms. Davis, anything else?
No, Your Honor. Thank you, Your Honor.
Okay, if you'll get that order drafted with a new child support worksheet over to Mr. McMullen for his review and approval as soon as you can.
I will do that, Your Honor.
Mr. McMullen, anything further we need to address from?
The final ruling shows a judge attempting to slow down conflict before it becomes permanent damage. By denying temporary spousal maintenance, approving shared custody, and restructuring support obligations, the court essentially refuses to reward either side's worst assumptions about the other. The judge's closing comments are especially revealing because they move beyond legal arguments and into long-term consequences. He appears convinced that both parents are capable, but he is equally aware that capability alone does not guarantee cooperation. The repeated focus on the child's future signals frustration with the adversarial posture both sides adopted throughout the hearing. In the end, neither parent receives everything requested. That is often how family court operates. The biggest winner is usually the parent who adapts fastest to the court's expectations. The next phase of this case will likely depend more on behavior than arguments.